Hi, I'm firearms attorney Gilbert Ambler, and today I want to give you a quick update on the ATF's Engaged in the Business Rule. We've done a couple of other videos on this. However, the effective date of May 20th is fast approaching, and there have been some pretty dramatic updates, largely coming from the Gun Owners of America case, which is GOA, VCDL, and a couple of states, that's Virginia Citizens Defense League, along with a couple of states against the ATF seeking to enjoin this rule. And the ATF, and this is one of the things that GOA complained about, the ATF moved rapidly with this rule. In fact, when they published this rule, they said the rule is effective 30 days from date of publication in the Federal Register. And that's different than most of the other rules that they've recently passed on things like pistol braces and frames or receivers. Why, you ask, would the ATF speed up the effective date? And the answer, I believe, is because they're sick of being challenged and those challenges striking down their rules in court. So they tried to speed it up. Fortunately, the judge in GOA's case seems willing to at least hear them out, having set an injunction hearing for May 16th, 4 days before the rule is set to take effect. So I want to update you guys a little bit about this case, and I want to talk to you about the scope of this rule, because we did a previous video where we talked about the fact that you cannot avoid this rule simply by selling guns to an FFL through a licensed firearms dealer if you're an individual and you otherwise fit the presumptions. However, in briefing, the ATF gives us some insight into who they think this rule applies to, and I'm going to read to you directly from their briefing, because I think you should be concerned if you are somebody who owns a lot of firearms, including if you're somebody who owns a business such as firearms training, where you buy a lot of firearms and use the firearms for that business training. And I'm going to go through this with you in just a moment. But before we dive into that, if you have not yet hit that subscribe button, what are you waiting for? Hit that subscribe button, like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting these important Second Amendment related updates. Now, the rule that we're talking about, of course, is this Engaged in the Business Rule, where the ATF attempts to clarify with hundreds of pages of rule a pretty straightforward and simple statutory definition of who is engaged in the business of dealing firearms, such that they are required to have a federal firearms license. Now, notably, in this definition of who is engaged in the business is found at 18 U.S.C. Code 921. So this is 18 United States Code Section 921, and their Congress defines who is engaged in the business as somebody who is operating with the primary motive of profit. They're purchasing and reselling firearms primarily to make a profit on the firearms. And they specifically exclude somebody who is purchasing and occasionally reselling firearms in furtherance of a hobby or in furtherance of a collection. Now, here's where I think ATF's briefing and the final rule itself is far wider reaching than many people have realized. And the reason is ATF very narrowly defines the term, clarifies the term, and defines the term collector to mean somebody that is operating not just a private collection of anything, but they've turned to a Oxford or a Merriam-Webster's dictionary definition. I'm sorry, not Oxford. Merriam-Webster's dictionary definition, where they say that it is a collector who is collecting firearms for purposes of science or display or comparison. So essentially what they're saying is, if you are collecting firearms because you like firearms, or you're hoping that they go up in value one day, or because you want to have multiple firearms around to defend yourself, this exclusion from the statute for somebody that is a hobbyist or collector does not necessarily apply to you. And I want to read to you directly from the ATF's reply brief in opposition to GOA's motion for a temporary injunction. Here's what they say. Personal collection is defined to mean personal firearms that a person accumulates for study, comparison, exhibition, for example, collecting curios or relics, or collecting unique firearms to exhibit at gun club events, or for a hobby. For example, non-commercial, recreational activities for personal enjoyment, such as a hunting, skeet, target, or competition shooting, historical reenactment, or non-commercial firearms safety instruction. The term shall not include any firearms purchased for the purpose of resale with the predominant intent to earn a profit, for example, primarily for a commercial purpose or financial gain, as distinguished from personal firearms a person accumulates for study, comparison, exhibition, or for a hobby, but which the person may also intend to increase in value. In addition, the term shall not include firearms accumulated primarily for personal protection, provided that nothing in this definition shall be construed as precluding a person from lawfully acquiring firearms for self-protection or other lawful personal use. Now pay attention to what they're saying to you here. They're saying that in their minds, if you have these firearms for personal use for self-protection, you don't fall within the collector or hobbyist exclusion, which means if you do any of the other things that bring you under the presumptions set forth in the rule, meaning if you sell a firearm within a year of acquiring it, if you sell a firearm that is in like new condition with the packaging, if you keep records of how much you paid for the firearm, if you do any of those things, you fall within their presumption because you don't meet the exclusion for a collector or hobbyist, which remember, they're trying to narrowly define, saying it applies only to those that are doing things essentially that a museum would do, displaying firearms or comparing them or studying them. These are not the actions of an average civilian who owns firearms, so they're trying to take that statutory exclusion and minimize it so that it does not apply to most Americans. This is very, very concerning. We need to keep our eyes peeled on what happens in the GOA case because this rule is certainly concerning if you own guns that you think have gone up in value and you hope to one day resell them. Stay tuned to this channel. We're going to keep you up to date on this update on this rule. If you enjoyed this content, go ahead and hit that subscribe button. Until next time.